Unfortunately, bailout case number was wrongly typed. That's why yesterday I filed this. He lost to fix it today, but it has not come.
Regarding item number 34, perhaps case diary.
Pardon?
Case number 34, man.
Yes.
Item number 34, man. Perhaps case diary is an interim order.
34. He did not list again. CS7.
Whether was appeared, man. Whether was appeared.
Charge number 65/2025,
Yes, sir.
dated 13/10/2025. 2025 is the charge number, and date is 13/10/2025.
Can copy. What?
They have already appeared, man.
No, you are in interim.
I'm an interim, man.
You will apply for regular bail then.
Apply for regular. It may be extended, man.
Submitted. So it is here before. Apply for regular bail. Then effective by extending the interim order pre-arrest bail dated
26/9/2000.
26/9, man.
accordingly application of then when the that the petition will appear before the trial court within a period of 15 days from in the event of any bail application. Same will become court. Till then pre-arrest dated will remain in petition. This
Item 41, in addition today. Regarding item number please get please.
it says with TCR 6 files
43 lots.
43. Item 43. 10 copy of still not received. List again on give the date.
7.
All right, 11th of December.
Oblige.
Item number 31 lots. The matter will be adjourned for
Item 31, list again on the prayer of learned council. The petition list the matter
Interim, my lord, so let it be on 3/12.
312. Interim is there.
interim is the lot.
Interim order passed. Till the next.
Item 40, last item. Books of Central. The party. After
On the prayer 48 on the prayer of learned council for the petition is the matter of 4 weeks.
Oblige.
May I plead your lord? I beg to item number 40, lord.
40.
40. Adjourn for lord.
40 passed over for the day.
December.
Hmm?
Part of
Please, your lordship. Beg to mention item number 28, lordship. In this matter, lordship, up to date case diary was called. Person up to there is not available.
Up to date CD not list again on
On 26.
SPP will say when you can get.
We have to send back the case there, my lord. They are on interim. 5th of December. ma'am.
No,
Interim may be
3 months past. Continue. Next day too.
deeply.
Hi, please, Lord. I beg. Adjourn.
42.
Prayer of learned counsel for the petition. Passed over for the day. Yes.
Carefully.
Connected to dim any order passed by me, then go to senior bench.
Item 35. Available.
The case diary not received.
35.
Not received.
Not it.
Case diary not received.
He did not receive list again.
Another item 38.
Same.
Same. In
Yes.
38, it is interim.
Interim order
35/8/12.
38.
38, my lord.
Same day.
Same day. 8/12.
I beg to- Item number 30, your lord. Matter may be at the day. 30.
30.
30 case
Any
diary
date
received,
next.
my lord.
Received. On the prayer of CD is received on the prayer of learned counsel for the petitioner. List the matter again on. When do you want?
Next.
Next week. 5th.
If 5/12. my lord.
Happy. Lord, on matter, my lord, 93 days in custody, charge sheet has not been filed, rejected by this honorable court. May I pray for list? Yes.
Prayer of learned counsel for the petition is dismissed as withdrawn. Yes.
Required to a hearing.
Yes,
Last occasion.
did we work for or not, that we have not
Not received.
strongly listed in the motion.
CD not received item is wrongly listed in the motion column. List the matter again.
My humble day after.
How do you know CD will come day after tomorrow?
Bajali.
Huh?
It's from Bajali,
You want day after tomorrow?
on Friday.
Friday.
Wait, please, your lordship. Lordship, the regular bail, second time, lordship, may the
Okay,
TCR may kindly be called for because lordship.
yes.
No.
Charge case.
Charge case, no progress in the trial, lordship. On the 180 days, this case
Call
was
for
rejected.
scan
lordship.
copy
Now
of
220 days.
TCR along with CD. List again on.
8. Publish.
Sir, bail application is allowed. That's section 316.
Hmm?
He alerts. NS earlier 407 alert. Space 41 and the barrier. Yeah,
Correctly said, Lord. The owner of the vehicle hired me to reveal the vehicle. Thereafter, I was
Who are
asked to
you?
release the vehicle to the permanent driver. Your Lord. I am the temporary driver. Permanent driver is Ismail Ali. Your
Who was driving?
Lord.
You are driving.
The first time I was driving, but thereafter I hand over the vehicle to the permanent
Oh,
driver Ismail Ali.
alright.
Ismail Ali
Didi.
also behind the
Yesterday, Lord.
third date secretary.
On 25th.
Mass of this.
Coming up for the second time. Earlier lordship was checked the bail application of the accused. These commissioners were arrested on 22nd of August. Don't they have completed 89 days in custody. Case of murder law 1032.
Take instruction. Whether
At two,
Always at two.
at two.
None appears call for the CD.
28th.
What 8/12? This is regular bail, I think.
Yes.
How many
Date of
days?
forwarding is 1510.
Huh?
Date of forward is 1510.
15/10.
Yes.
More than a month already.
Let it be if
Already. 5th. But same council.
from same PS, a different PS. That same person.
Hmm?
Mahibul
I
Hussain.
think same council, I think.
Yes, same petition. A different.
It is the offer.
On 5th of February.
Alright. Same date.
Wait, please, your lordship. This case was rejected once, your lordship. I'm filing it for the second time. Your lordship, the prime accused is granted bail.
Huh?
A murder case, your lord. It was rejected once. The accused who were named in the FIR are granted. Because I've been behind bars for the last 45 days. In that aspect,
You may call for topic.
your lordship was done bail to the named.
Do we have to see the CD?
May I pray for a very short day? It's from San Maria.
On 25th.
Second case also same year.
Alright. Item 8, same order.
25th.
Deeply obliged.
Any report?
Yes, Lordship. No case has been registered against Saddam Diwan, Nalbari P.
On instructions received, learned additional PP submits that no FIR has been registered at which PS?
Lordship, it's Nalbari PS.
Nalbari PS against present petitioner Saddam Diwan. Accordingly, matter is dismissed as withdrawn.
Like, it is a-
File to attach করে থৈ দিব।
Status report was called for from Hatigao PS Lordship. Respect whether any case is pending against the petitioner.
If till date, no instruction. Have re-
Can it be on Friday?
Depends whether you can get the instructions.
Friday.
Friday,
Lordship.
same order as the previous one. Continue.
What?
Please. Any instruction?
Yes, Lordship. Receive the instruction. There is a case registered against a petition. Connection with Bongaigaon PS case, the entry number 37 dated.
None appears for the petitioner. Turn an additional TP on instructions received as submitted. No such case has been registered against the petitioner Jyotirmoy Bhagavati corresponding to Bongaigaon PS GDE number 37 dated 5/10/25.
This is part of it. No.
Accordingly, petition stands closed. Hmm. Fifth, I think.
Yes.
Earlier date. The Lordship in the item number 6, the phone arrest. The first case is the fraud.
You have missed the bus. Yes, next item.
Short date. 30 Lord.
Mhm.
And daily FIR is 10.
Yes.
Ellie. Pass. Thereafter thereafter the other side as well. So registered match. Thereafter, my lord, the party compromise the match. I have page 9.
Nobody was arrested.
Accused number 1 was arrested. Thereafter was released on bail. I have payload resume. Your lord, correct. And
Where is the trial court's order is there?
I
Only says nature of allegations. Period of detention.
Yes. Sir,
Speak a little louder, we can hardly hear you.
there is just the FIR made. A specific allegation. One is and other third photo. Per accused.
Let us call for the case. Case involvement might
Called for. Also annex the compromised.
compromise 126-109 or
The FIRs, my lord, were filed out.
Already heard learned counsel, an application under. The allegation as per the FIR is that the accused number one named Samsuddin attempted to kill the informant by strangulation, while other accused persons demolished his auto rickshaw. So call for the CD. Para having regard to the fact that the main accused has been granted regular bail by the learned court below. The order dated 10/25 in bail petition 442 of 25. It is provided in the interim that petitioner in the event of his arrest 20,000 considerable. Order provided that is cooperated with the investigation appear before the IO in a period of 7 days.
eighteen
Yes.
I'm sorry, Lord, I missed the item 11, Lord. It was status report was called for.
Yes. We have passed the order.
Lord,
Yes.
Please, your lordship. I am being led by senior counsel. Came on legs before court number 8. After some. Achoo.
Yes. What is this?
Yes, I did.
Oh. None appears for the petitioner. Is the matter again on?
Obliged.
Yes.
The earlier location, your lordship is framed the question of maintainability of the petition because
Hmm?
appeal lies under section 29 of the DV Act, my lord.
One judgment of honorable court, my lord,
Hmm?
clearly said, my lord, judgment of honorable Supreme Court, my lord, is maintainable.
Yes. What is the judgment?
What?
Hmm?
Criminal appeal number 2688 of 25.
Yes. You marked the paragraph where it is said.
39, my lord, last.
Yes. Pass it over.
Is the court of
This is the judgment. I also got a judgment.
You're sure it is the same judgment?
Yes, same, my lord. Party name is Saurabh Kumar Tripathi.
Yes. Paragraph.
39, my lord. Last, normally interference under section 482 is warranted only in case of gross illegality or injustice. In DV cases.
No, in the present case, what are you challenging?
My lord, the interim maintenance as well as the proceeding.
Then,
DV, my lord, kindly see section 3 of, my lord, the protection of women from domestic violence. My lord, kindly see for the time being. Section 3, my lord, kindly see section 3 of protection of women from domestic violence act.
yes, DV Act. Yes, you can read.
Yes, ma'am. Definition of domestic violence. For the purpose of this act, any act, omission or commission or conduct of the respondent shall constitute domestic violence in case it harms or injures or endangers the health, safety, life, limb or well-being, whether mental or physical, of the aggrieved person or tend to do so, and includes causing physical abuse, sexual abuse, verbal and emotional abuse, and economical abuse. The harassment harms, injures or endangers the aggrieved person with a view to coerce her or any other
So
person.
what is the allegation against you?
Yes, my lord, that is there, madam. Page, my lord, 24.
Hmm?
Page 24, my lord, of my petition. This is the allegation, my lord, torture, etc., my lord.
So what more is required?
Yes, my lord. Kindly see page 15, annexure A, my lord.
1-5.
Yes, my lord. 1-5. Respondent number 2, my lord. He left the matrimonial home without any sufficient reason, as my lord, she had taken loan from bank as well as from self-group. She could not repay, my lord, for which she, my lord, left the matrimonial home. Page 8, page 13, my lord. Annexure A. This is the, my lord, demand from my lord bank authority. From Gramin Vikas. So, my lord, she left the matrimonial home without any sufficient reason. Only for pressure.
This is a loan demand reminder from the bank.
Yes, my lord.
So how does it negate this pleading that
Yes, my lord.
since the
She left
respondent was started to torture?
matrimonial home, my lord.
Huh?
Only for this reason, my lord. She left the matrimonial home.
We don't know. That is a matter of trial.
That is there, my lord. Number
Then-
2, my lord, kindly see page, my lord, in the 17. my lord, a village mail was, my lord, constituted
Hmm.
on 1/12/2020, my lord, regarding the arson of done by respondent number 2, my lord. On 30/11/2025, my lord, 30/11/2020, my lord, the respondent number 2 established the house of the petitioner, for which a village mail was constituted, held, and decision was taken, my lord, resolution in this meeting, page 18, my lord. In this meeting, resolution is accept to the effect that the local people condemn the offense of person committed by Srimati Kunja Gogoi, that is respondent number 2, in her house. And in this respect, resolution is taken for proper action to the accused after adjudicating the matter as per
These
law.
are also matters of evidence.
But this will negate, my
How,
lord, the.
how can we
the
throw it
public
out at the
proceeding, my
threshold?
lord. Number
How
3,
will
my
it
lord,
negate the proceedings? The proceedings, you are taking the court's attention to section 3, definition of domestic violence. As per the definition, it is clearly present in the complaint petition.
there is no, my lord.
You are
there is
trying
no-
to introduce evidence to show that that doesn't exist. How can that be permissible in a revision?
That for, my lord, kindly see, my lord, order dated 2/8/23, my lord, page 46,
Yes. Order of this court, magistrate's court,
my lord,
magistrate,
page,
CCM Dibrugarh.
yes, my lord. Not the prayer is allowed, pay is a fees for order on petition number so and so, cross examination of so and so. Had both sides on point granting interim maintenance perish case record. Seen petition number so and so filed by the petitioner. Thereby praying for granting interim maintenance on ground that the petitioner does not have any sufficient means to maintain herself. It has been further stated that the petitioner is facing tremendous financial crisis and that respondent number one does not provide any maintenance to her. My lord, heard the petitioner, I have gone through the main petition, taking into account the financial condition of the aggrieved person. I am of the view that it is a fit case where interim maintenance can be granted. My lord, at the time of passing this order, my lord, my lord, WS as well as objection has not been considered. Without considering that my WS and my lord, objection, this order was. So this is one of the illegality, my lord, for which this case is filed, my lord. Considering, my lord, by
You are Thuleswar Gogoi.
Sir Gogoi.
You are present as reflected in the order.
But my lord, my WS and objection was not considered. My. It was nothing is there. My lord, kindly see now in order said clearly, my lord, closed it.
Your affidavits have been gone through. Affidavits of assets and liabilities have been gone through. It is an admitted fact that you were living separately. It has emerged
It's
that
not for my fault, my lord. It is, my lord.
those are matters of trial, not a matter of crossing.
But my lord, prima facie it is clear, my lord, from this.
What? Where is your objection? 36.
My lord, objection is, my lord, 36 and written statement, my lord, 38.
Yes, so your only ground is that your objection was not considered.
Yes. the trial, my lord. That is the, my lord, left the matrimonial home without any sufficient. He left the matrimonial home without any sufficient.
That is to
Only
be
to the
decided
pleasure-
by the learned trial court. We are not to decide that. No case of quashing has been made out. So let the magistrate hear you afresh on the objection filed by you.
Yes, sir, definitely.
Pass
It's
the
not
order.
the pleaded ground, it is not the pleaded, not the ground, my lord, that objection not considered. So, see the ground at page 10, my lord. They have taken all together, my lord, 5 grounds, my lord, 6 grounds, not the ground, my lord.
Page 12, my lord, kindly. 6, ground number 6, my lord, kindly. Sir. Any of the matter, the learners,
By that line, you can cover everything. Any view of the matter.
My lord, second thing is that, my lord, my friend has made 2 prayers. First for quashing of the proceeding, second for order. For the purpose of quashing the order, my lord, appeal lies. For the purpose of quashing the proceeding, my lord, the petition is maintainable. Otherwise, my friend in the guise of 42, my lord, challenging the order, my lord. It is not maintainable because lordship may see section 29 of the Domestic Violence Act. The judgment which my learned friend has relied, my lord. Honorable court has held that, apex court has held that, my lord, for quashing a proceeding, the petition is maintainable. It not said, my lord, that order for order is maintainable, my lord. First of all. Second, my lord, the paragraph 35 of the judgment which I have relied, my lord. May I read, my lord?
Hmm.
The judgment I have given, my lord, 35, my lord. Internal page 13, my lord.
Yes.
Page 35. When it comes to exercise the power under section 42 of the CRPC in relation to application under section 12(1), the High Court has to keep in mind that the fact that DV Act 2005 is a welfare legislation especially enacted to give justice to those women who suffer from domestic violence and for preventing acts of domestic violence. Therefore, while exercising jurisdiction under section 42 of CRPC, the quashing proceeding under section for quashing proceeding under section 12(1), the High Court should be very slow and circumspect. Interference can be made only when the case is clear gross illegality or gross abuse of the process of law. Now, my lord, here, my lord, nothing has been alleged, my lord. No ground has been taken. There is no material available on record to show that there is gross illegality, my lord. This case of pertaining to domestic violence only, my lord. And whatever the ground my learned friend has taken are all factual ground, my lord, which requires, my lord, evidences to be considered, my lord. In my humble submission, my lord, it is not able to be dismissed, my lord. If you want to challenge the order, he can go for an appeal also, my lord.
Yes. Anything else to submit? All right. CAB.
Much obliged.
all right.
Right, Mr. Lordship. My lord, the informant and the petitioner, their brother-in-law, my lord, they both reside in a property, my lord, given to them by their father-in-law.
Just a moment. No, Niana. This one.
As I submitted, my lord, the petitioner and the informant, they are both brother-in-law. And they are both residing in the same building. The property belongs to, my lord, their father-in-law. Now, apparently, my lord, there are something going on, but then on that eventful day, my lord, there are cross affairs also. And that apart, my lord, the petitioner before lordship is an advocate from this honorable court. Now, the affair is at page 12. That with due respect, I beg to state that today at about 2:10 p.m., my younger brother Moinul Haq, while coming from his son to his home situated at Hizubari House, Swenslow, below name accused in a pre-planned manner engaged in quarrel with my brother and with a view to kill him started blow on the head and other parts of the body with some, and as a result, my brother sustained various head fractured finger, and he became senseless. At present, my brother is fighting with life at the in a case. This is the FIR lodged by the informant lord. And as far as our FIR is concerned, that is at page 18. With due respect, the humble submission is that I, the undersigned, hereby inform you that since long my husband, the husband of my own elder brother, namely Monukak, has been torturing us in various ways. Yesterday on 3/11/25 at about 11, the said person indulged quarrel with me and assaulted me and my husband, Manuddin, armed with wooden button, causing injury on several parts. Moreover, he also broke household articles. Thereafter, I with my husband entered into our and locked from inside, but he attacked the door and by hand and feet and broke the. Today at about 3 p.m., while my husband was sitting in his said Sri Moinul Haq started deep and cry by wooden button. Then my husband came towards the pair of sleeping. At that time, Moinul attacked my husband with the button and caught the button. During scuffle, the wood button head of the Moinul was himself and thereby injured. Therefore, the
So who is in hospital now? You or the informant?
he has been released. But he was, after first aid, he has been.
Yes.
I'm for the informant. Kindly there was the medical.
Lord, let this is there be used that an independent prosecutor kindly
Vital.
So fracture is there, but only on the hand, not in the vital part. Vital part, there is no fracture.
It also there is
Stitch is there, but appears to be superficial, sort of. See, stitch will be there even if the skin breaks, is it not? You have no photos of your own.
CCTV footages are there, I'm told.
All right, heard Mr. K. Choudhury learned. Additional PP. Also heard Mr. appearing for the informant. The allegation is contained in the FIR that the petitioner, who is the brother-in-law of the injured victim, brother-in-law
Yes.
of the injured victim, attacked the injured person, attacked the victim with a wooden bottom, causing previous injuries on the head and fractured his hand. As a result of which he had to be hospitalized. Sir K. N. Choudhury learned senior counsel submits that the incident which took place was in the nature of a mutual fight, and in this regard, the petitioner wife has also lodged an FIR against the victim of the present case. The perusal of the said affair shows that similar allegations have been made by the petitioner side as well against the victim. Learned counsel appearing for the victim informant has submitted a set of photographs of the injured victim along with a report, with a medical report which indicates fracture of the hand. Call for the CD. Having regard to the above, the nature of the injuries, it is provided with in the event of his arrest in connection with the affected case. Released on interim pre-arrest bail of 50,000 with one security to the satisfaction. Petitioner shall appear before the IO within a period of 7 days from today and shall not try to influence or intimidate the witnesses in any manner. Yes, give it.
City along with the injury.
CD along with injury report. Photographs and let that be on the record. Photographs and injury report submitted government the file. Yes,
It
F2 we don't know, but after some time we'll.
May this is your lordship. Lordship, I beg 1 week's time to file my affidavit.
Item 15,
16, lordship.
16. You are for?
I'm for respondent number 2.
Yes.
After 2 weeks, Lordship.
1 week, lordship, I'll file because next date fixed in the trial court is on 29th. So before that, I'll file it. This week only I'll file it. Let it come up.
Otherwise, there is no stay order.
Yes. But what is this against?
Because a domestic violence
The
case.
cognizance order
Uh,
at page.
so you're challenging the cognizance. So what
Cognizance
is
order.
your objection to that? If the date is fixed,
I'll file my objection to the case. He went for
Learned
cooperation.
counsel appearing for respondent number 2 prays for a week's time to file objection. Accordingly, list the matter again on. Give a date.
Can it be? If you.
Yeah, Lordship. There has been settled with the parties for the mediation.
Withdraw.
Want to, some condition is there, my lord. I want to withdraw, but with some condition, my lord.
How can we impose conditions in the absence of the other? Is there?
Then let me appear.
This
by the
report of mediation has been received.
mediation.
No,
report
say
is
that.
there.
Any private respondent?
Yes, my lord, respondent to appear, my. Is appear, my lord, on the next. Last date, my.
Okay, since mediation report has come, I think we can dispose of this.
Lordship.
Hard learned counsel for the petitioner. None appears for respondent and it is there.
State is there.
And additional PP for the state. None appears for the private respondent. It appears that the matter was sent for mediation and a report of the mediation has been received, indicating that the parties have settled the matter under the terms and conditions mentioned in the agreement annexed to the report of the mediation center. There are also perused the order dated 27/10/25 passed by the Secretary IC Guwahati High Court Mediation Center, stating that both the parties have agreed to settle their disputes voluntarily on certain terms and conditions. There is the memorandum of compromise dated 14/10/2025, arrived at between the petitioner and respondent number 2. In view of the settlement arrived at as a result of the mediation, the instant petition is disposed of on the terms and conditions contained in the memorandum of settlement dated memorandum of compromise dated 14th October 2025. The same be kept as part of the record. Petition stands disposed of accordingly.
Lordship, in this case, Lordship, I have to file objection, Lordship. Let it come after 2 weeks, Lordship.
The prayer of learned counsel for the petitioner.
2 weeks, Lordship, I have to go through the LCL, Lordship. LCL is their Lordship. No, several pages are there, Lordship. I have to go through, Lordship. Perhaps I have to take a certificate, Lordship.
And the matter is fixed. 10.
We will have it before that.
If the
On the prayer of
FIR starts
learned
with
counsel for
Lordship.
the respondent, release the matter on 5/12. In the meantime, respondent number 2 may file objection.
Lordship.
So right, TCR has been received.
By please. Offense.
TCR is received.
There was call for my, it has been received, my lord, and the case of 64, my lord, of BNS. And on 10/11/2025, cognizance has been taken.
I have been behind the bars for last 7 days. FIR pays Lordship 8 Lordship. Summary of the FIR is that Lordship, day of LS, the victim came to pluck some flowers from the place, place of the petitioner Lordship. And Lordship, some altercation took place, Lordship. And the petitioner taking the chance, he dragged the victim to his house and raped her. This is the allegation. The fact is that, Lordship, the victim, Lordship, used to come to pluck the flowers from the flower garden of the petitioner, Lord. And Lordship, the victim used to come, Lord. And on the day of alleged occurrence, Lordship, he was prevented by the petitioner, Lord. And that's why, Lordship, altercation took place between the parties, Lordship. and therefore, Lordship, the petitioner was falsely convicted in this case, Lord. Moreover, Lordship, I have been behind the bars for last 67 days. Lord. There is no any criminal antecedent against the petitioner's Lordship. And the victim, Lordship, is a married woman, having her family, Lordship. And I am also, Lordship, I am also having, Lordship, family, Lordship, and also children, Lord. Both the victim and the petitioner, Lordship, are the villagers nearby, living nearby, Lord. Lordship, since the matter has been considered, Lordship, investigation part is complete, Lordship. And Lordship, I am ready to cooperate with the proceeding, Lordship, started, Lord. Lordship, further detention does not serve any purpose. The permanent resident of the petitioner,
That is not the only consideration.
Lordship. Ready? But there is just most influence the weak as both
Medical report also supports her version.
is a married woman.
No, not that part.
Married woman. She has having family husband also.
Her allegation is that she was slapped several times, and that
Was
that is
not that, my lord.
that is substantiated by the medical
Yes.
report. So her version appears to be true.
I'm ready to cooperate with the
It
on
has
any
been
terms
filed.
and
What is there
conditions.
to?
67 days, Lordship. If otherwise, Lordship, Sashit is not submitted, Lordship. 90 days was the statutory period, Lord.
Come on, 90 days.
Oh, Lord. Kindly allow, Lord. I'm ready to cooperate with the any terms and conditions. I will appear before the learned trial court below, Lordship, on each every case, Lord. I should.
I'm trying to find some lacunae in the prosecution case, but I have not been able to do so. So I can't help you. I'd learned counsel for the petition. Also heard. This PP decision application pursuant PCR as called for has been received. The allegation against the petitioner is that when the victim, who is a married lady aged about 40 years, had gone to pluck flowers for puja, the petitioner enticed her to his house. Thereafter, assaulted her, committed rape of Sarah. Perusal of the record appears that the petitioner has been squarely implicated by the victim, and her allegations are also supported by the medical report, which indicates injuries on the person of the victim, which are relatable to the assault allegedly made upon the petition. The gravity of the offense, prayer for bail is rejected at stage.
My lord, case diary not received. Then, my lord, we have to go to the, my lord, in fact, for this scan copy has not been shown, my lord. Let it come day after to go to the scan copy.
Lordship, scan copy received, Lordship.
Yes, received. I have told that for this is not.
This is item,
Item 20, my lord.
Item 20, Lordship. Lordship, I mean,
it says office note.
more than 150 days, already charged case, Lordship.
What is the offense?
Lordship, offense is I am charged with under section 1031
All right,
main section.
day after
murder,
tomorrow. It appears that PCR has been received. Learned additional PP praise for another date so that he can go through the PCR. Hence, release the matter again.
Lordship, kindly
No, day after tomorrow.
PCR was called for, my lord. Allegation number one, my lord. He has a jewelry shop, my lord. Buy jewelry, my lord.
Receive.
PCR
TCR received.
to buy, and my lord, the item number 20, my lord. Same person, different case. That case, they are behind the bars for almost more than 80. 140 was granted bail, my lord. That is different case, my lord. But here, my lord, the allegation that petitioner number one, my lord, used to buy stolen jewelry, my lord. The jewelry. Kasif submitted my father custom requirement.
So in present case, around 56 days.
Here, my lord, around 56 days. 30.
Yes, PP.
My lord, lordship, may kindly see, my lord, item number 22, my lord. This is the Dhekiyajuli PS case number 237, my
22.
22, my lord.
Here, my lord, 80 days. 80 days in custody.
Yes, but what do you want us to see?
Dhekiyajuli PS case 237, my lord. In this case, my lord, they were arrested, my lord. In the other case, my lord, Thelamara PS case number 72, my lord. They were, in this case, my lord, they were shown arrested, my lord. So they were already in custody in connection with Dhekiyajuli PS case number 237.
What is the occurrence of the item 21? When did that take place?
Now 21, my lord, I have given a flag mark, my lord. Lordship, may kindly peruse. what basis they have been arrested. Yes, can copy. Can copy the dude.
First flag mark is statement of a witness, Hemanta
No,
Chakraborty.
that's the second one, my lord.
Second one, his prayer for shown arrest was made. That is what he
Yes,
says.
it
Then
is
that
what
was
I-
allowed.
Why they have been shown arrest, my lord? Because in this case, my lord, the direct my lord, material has not been able to collect by the IOM. Kalamara case. It is why, my lord, it is the note of the investigative. My lord. I have. Because witnesses is implicated some other person.
অনারেস্ট কৰাৰ বাবে মহামান্য আদালতত এখন প্ৰেয়াৰ দাখিল কৰা হৈছিল আৰু সেইমতে মহামান্য আদালতে পদক্ষেপ 2 দিন 2 ঘণ্টাৰ বাবে সোধপোছ কৰাৰ বাবে আৰু অনাৰেষ্ট কৰাৰ বাবে হুকুম দিয়াত পৰৱৰ্তী সময়ত পদক্ষেপ সোধপোছ কৰি তথাপিত ব্যৱস্থা গ্ৰহণৰ বাবে
The previous note, my lord. Also peruse the previous note of the IOM. Previous note prior to.
No, the question is why were they shown arrested in this case? What is the material?
Suspicion, my lord.
It is the statement of that person that suspicious he was moving around in that area.
No, that person is different. My lord. That is why I have flagged it. This is indicated one
Another person.
another person.
All right. Well, length of detention is there. Otherwise, there doesn't appear to be any
Telling my
material.
lord, other case, my lord, 22, my lord, scan copy has not come out.
No, my lord, it's charge sheet. 80
22 charge sheet not submitted.
80 days in custody.
That will, my lord,
Item
second
20
item, my lord, investigation is pending.
item 21. Third learned counsel, the petitioner. Third learned additional. This is an application under suspension. The facts as disclosed by the FIR is that the informant discovered that his shop was robbed and all the things were messed up and locks were broken. No, not in his shop. Right again. As per the facts disclosed in the FIR, the informant has stated that when he woke up on the morning of 8 a.m. morning at 8 a.m. His neighbors who were living in his rented house informed him that there was a robbery in their rooms and all things were messed up and locks were all broken. Full stop. The present petitioners were shown arrested in the present case as they were shown arrested on 25/9/25 in connection with the present case, that is Kalamara PS case number 72/25 under section 305 within bracket small a stroke 331 in bracket 3 PNS, as they were already in custody in connection with Hekiajuli PS case number 237/25 under section 305 stroke 331 within bracket 4 stroke 3 within bracket 5 of BNS. Since 01/09/2025 perusal of the CD does not reveal any specific material against petitioners in connection with the present case, and having regard to the period of detention of about 57 days, and also the fact that the charge sheet has already been submitted, the prayer for bail is allowed. 20,000 security. They will participate in the trial in case one comments disposed of.
Like, more than 80 days in custody.
The case diary because
Like 80 days in custody. Further custody. Same allegation. But man, here man, allegation for forwarding it. Yes.
Same CD or what? No.
No, CD will
Cannot
be
be
different, my lord, but man, 80 days in custody. Other custody.
it is on Friday, my lord.
Mal-
What is the
mal-
case diary?
But you may kindly see 80 days in custody.
They're paying for only 2 more days.
My lord, I meant jail for 80 days. Father, same thing will come, my lord. So my allegation is that my petition number 1 purchase the jewelry, my lord, forward. Purchase jewelry case. Page 17, used by mark. Or 80 days in custody, my lord. Investigation has completed. Other custody. Any condition. Page 17, paragraph 7.
You are the receiver of stolen property.
Petition number 1 is the receiver, and petition number 2, my lord, he used to help, my lord. That is the allegation.
Help in what manner?
Help because it is doing some logistics support like that, my lord. But my lord, total 80 days in custody, further custody, my lord. Page 17, my lord, is regarding, my lord, the petition 1.
I don't think you can get the CD in 2 days.
So may kindly come to page number 24, my lord. Bail application. Last paragraph, my lord.
KMFC, my take my the case, session, my session tribal, my KMFC case. stringent condition, my lord, they are
Your name is Nur Hussain.
Noor Hussain and Tafazul, my lord.
Tafazul name is there, my lord.
Huh?
Tafazul name is there. Noor Hussain, my lord.
80 days in custody.
Noor Hussain purchased the, my lord, stolen ornament.
That
Page
is the
number,
allegation.
page number 25, first paragraph, my lord, last.
On the length of mention, my lord. We will
And
pay the-
Tafazul Hussain, my lord, he provided, my lord, logistic support. Conspiracy part cannot.
But 305, my lord, that 90, that not a person. Allegation. Three 31 4 months. Not be is to person.
The entire CD is in the magistrate's order.
Help. I am praying for only 2 more days.
My lord,
my lord.
2
If
more days,
we
you
could not
won't
provide,
have-
we could not produce the case diary, my lord,
My lord,
then I
2
leave
more
it
days,
to
my
your
lord,
mercy.
kindly grant, my lord. 8 days in custody. Further,
That you are thoroughly involved, that is almost certain.
but any condition, my
That is why we are
lord, on any condition.
disinclined. Otherwise,
Any condition.
we'll grant him 2 days time. Wait for 2 days.
My lord, kindly grant, my lord, 2 days time, my lord.
All right, we are granting 2 days time for the CD.
On the 21st, my lord. Friday will produce.
Thursday, my lord. Thursday.
What will happen if it doesn't come?
Won't come, my lord. My lordship, kindly. 80 days.
Last time, my lord, 21, my lord, will produce the case diary.
What is last chance? This is coming for the first time.
Second time, my lord.
Second time, my lord.
What?
This is second time, my lord. Second time.
All right.
Kindly grant.
All right. Bring on Thursday.
My lord.
We did not. List again on Thursday.
Oblige your lord.
Behind the 59 days, it on 1
PM report.
9. Right. First call for an
The postmortem report is pending. my-
earlier. The case
This is a murder case, is it not?
Murder
Nothing
case.
like this, Minister. Earlier CD was very slow. Only Lordship. Was murder was Lordship. I think Lordship earlier was moment. Air paste still type. Couple of paste.
Yes, anything in the CD.
Lordship may kindly Feroz, my lord, the statement of Amol Das, my lord. He has given my lord statement, my lord.
Yes, read, read.
Yes, my lord. Not reading the entire, my lord.
All right.
Relevant. We decided to have some food with rabab tenga and brought 54 rupees while drinking This is Kasi I was holding. After that, he brought more bottles. Hero then abused me using slang language, grabbed my face and chest, and tried to remove the gamusa I was wearing. He also hit me on my leg. I moved away and sat in another seat. While sitting there, Hero came towards me and again dragged me. He opened his t-shirt, threw it on the ground, and appeared ready to attack me. I became angry, found a bamboo nearby, and struck Hero on the head, causing him to fall. I hit him again on the head, causing bleeding. I am the only person who hit Hero. My intention was not to kill him, but to teach him a lesson, as he had always been cheating and disturbing me. After that, I made
This
his
is the
valuable-
statement of?
This is the statement of one of the co-equals, my lord, Amol Bora, my lord. He was also present and they were drinking, my lord. But my
I am
lord,
for
the,
Puno Pura.
regarding my lord assault part, my lord, it is the statement of the my lord co-equal.
So he has not implicated him.
I am for Puno Pura, Lord.
The post-mortem report is yet to receive, my lord.
So even if a postmortem report will certainly show cause of death as
My lord, his
Injury.
statement record must as a confessional statement, my lord.
Hmm?
But I do not know, my lord, can it be this is not the format, my lord, according constitution.
But regardless of format, we have to go by what is there in the CD.
Yes, my lord. The direct evidence, my lord, against
For the present, we have to go by that. In the trial, that's a different matter. I'd learned counsel for the petitioner. PM report has not been received. Then application for regular bail. As per the FIR, the elder brother of the informant was killed by some unknown culprits at Vrindavan Weekly Market. Where is that? Vrindavan by Hata Sariali. By Hata Sariali. On 20/09/25. Full stop. Para, in course of investigation, the present accused was arrested on.
21/9.
He has spent how many days? 57.
59 days.
59 days in custody. Perusal of the CD. There does not appear to be any specific material implicating the petitioner in causing the death of the deceased. Having regard to the above, prayer for bail is allowed. 50,000 one security. Satisfaction. Same.
Regular bail. My lord, FIR is at page 13. Repeatedly- Page 13. I read the FIR.
Yes.
I beg to say that today on 1/10/25 late night at about p.m., while I was carrying 6 numbers of cattle in my DI vehicle bearing so and so and reached near the Pukuri part, the above named accused persons collusively using armed with deadly weapons intercepted me and asked me to stop the vehicle. As soon as I stopped the vehicle, the accused persons demanded rupees 1 lakh from me. I handed over 10,000 to them, which I had that time. Then they assaulted Sukur Ali, who was inside my vehicle, and when Sukur Ali raised obstruction by raising his hand, they assaulted him and his hand received cutting. Later on, when they failed to take money, they asked me to take out the cattle from the vehicle. When I refused, the accused persons took down one buffalo from my vehicle, and when they were trying to get down the other cattle, the local people gathered. All the accused persons except accused number 4 fled away by their motor. The present petitioner is for 5 months. although he was with them, my lord, he was not at all involved in the occurrence. The only ground for implicating him falsely because he was connected with politics and because of political, my lord, rivalry, my lord, he has been false. Here case diary has been called for.
Yes,
The informant, my lord, he was carrying, my lord, 6 numbers of cattle, my lord. Then this accused 5 numbers of accused person, my lord, they stopped the vehicle and demanded 1 lakh rupees, my lord. Then immediately, my lord, the informant gave them 10,000 rupees, my lord, but they have not agreed, and they tried to, my lord, took 1 cattle from the vehicle, my lord. Then, my lord, villagers came, my lord, and villagers apprehended 1 Nur Islam, my lord, on the spot, my lord. Other accused person fled with. He was arrested later, my lord. So witnesses are also implicated, my lord, and 1 person is sustained injury, my lord. His statement also recorded who was in the vehicle, my lord, with the he has also implicated this person.
Not taken, my lord. Official cattles are also there.
Cattle they could not take, my lord, because the in the
Also,
villagers
they did
came,
not
my lord.
take the money.
There is a 1 person, my lord, apprehended by the
Um,
villagers on the spot.
what is the name of the present petitioner? Abdul Salam,
Petitioner Abdul Salam,
number 5. Has anybody identified him as being present?
Yes, my lord.
Yes, my lord, he was
Injured
present.
person, my lord. So they have also given 1 dow blow, my lord. The Sukur Ali, my lord, who was in the vehicle.
The blow was given by whom? Anything is there?
That is not full, my lord. Only mention the accused person.
What is the injury? Report is there.
Report is not available.
Cut injury on his hand as per the nothing stated.
Who inflicted the card blow, my lord, that is not clear. But this person was also present, my lord, among the five
Yes,
victims.
present, my lord. He was traveling with them. But
Not traveling, my lord. He was with them to commit the doctrine.
nothing specifically is although he may be with them, but he has not taken part in.
What were you doing them with them at 3:30 a.m. in the night?
My lord, they
Unless-
are neighbors, my lord.
They may be neighbors.
Yes,
But you were
and he is a, my lord, I have stated in my petition.
you were not found in the neighborhood club, was it?
Yes, my lord. Because of this political, my lord, he was connected with politics, and because of that, at late night also he used to come back.
Who is
home,
in
my lord.
connected with politics
At
nowadays?
para 4, my lord, I have stated. Page 5.
The dacoity is serious offense. It is not just mistakenly. We're part of a gang. Unless your support was there, the rest would not have attempted.
Charge.
dacoity. How many days?
They come, my lord, 29 days.
No, not even a month then. Stay for some more time. I'd learned counsel for application to ensure the application to the
My lord, in the FIR also, nothing has been specifically it is stated again.
is that a group of persons as named in the FIR intercepted the vehicle of the informant in which he was carrying 6 numbers of cattle and demanded his 1 lakh from him and also assaulted his companion, causing cut injury on his hand. The assailants also extracted rupees 10,000 from the informant and also attempted to take away the cattle from his vehicle, but were prevented from doing so by the arrival of the local people on the spot. And except the accused number 4, the rest fled on their breastplate. Carousel of the. It is submitted on behalf of the petitioner that the petitioner has been falsely implicated on account of political rivalry. That no specific of such political rivalry has been stated in the petition. On perusal of the CD, it is submitted by learned NLPP that the injured person has clearly implicated the accused present petitioner as part of the group of 5 persons which was involved in the alleged offense of attempted dacoity as well as extortion. Having regard to the gravity of the offense and the material available in CD, the prayer for bail is rejected at this.
Been implicated because of the father of the man.
No, in this case, my lord, IO has paid for some time to put the case there.
Yeah, what is in 71 days. My lord, kindly see the FIR. Is the only my name has been implicated because of I am the father of the son. Son name is mentioned in the court. My lord, kindly see page 11. FIR. In middle.
Your name is?
My name is Kumaresh Das. However, my lord, I have seen Shanu Das Chaudhary, son of Kumaresh Das Chaudhary, running away with that blood-filled sharpened weapon from the spot of it. And what is this? What is the incidence, my lord? The Shanu Das Chaudhary, victim is the son of the victim is the my lord, the friend of the Shanu Das. My lord, kindly see page 3, para 4 and 5. What happened in how I have been implicated. A dispute and the altercation amongst a friend who were sitting under a banyan tree. Due to their altercation, that was stupid. I being the father, my lord, being the father, my name has been 1 days, 59 years.
To peruse the case there, my lord, and with the injury report.
Kindly see the page 3, para 4. 71 days. Kindly see, my lord, page 3, para 4. What happened, my lord? One days.
You keep saying 71 days, but I find no reason why you should be falsely implicated
My lord.
Your story is that your son and that fellow got into a fight,
The
got
FI is-
injured.
FI is-
Why should the police arrest you?
Because I
Does it
have-
happen normally?
My lord,
In case of every accused, does it happen normally that the father is also arrested?
generally, my lord, because the father, because that blood-stained, that weapon was recovered from my home. My- After committing the offense, my lord, the son entered the home. I was not at home. That weapon was recovered
What?
from my home. That weapon, my lord,
Ah.
which was used, that is recovered from my home because it is I being the father, my lord.
That is what you contended. That is why you were arrested.
This is the reason of arrest
Why would he be arrested for that reason?
because it is mentioned by the police itself in 48
If the
notice.
statement of the victim was that it is only the son who assaulted,
Yes,
why would the police arrest him?
it is in the FIR itself. The son has committed the, and even
No, in the FIR, all of you were there.
My
Why do you
name
keep saying only son is committed?
name is already mentioned.
Lordship, may I kindly say what is the injury?
It is
caused in the
it is
vital part of
named in the
body?
body of the FIR itself.
Yes, my lord, kindly see page 12. The reason is that weapon was recovered from my home.
Let the case
There is
diary be
a
called
police-
for,
police
and
by-
the injury.
These are not verifiable without the case diary.
My lord, 71
Weapon
days.
may have been there. What is,
Police mentioned
we
that.
don't even know what is the nature of the injury.
On 28, my lord.
My
They're
lord,
just fixing after 10 days.
I will, my lord, appear before police and my lord will my lord cooperate with the investigation. Best time.
Let us have it 24th.
25th.
Not a received list again on 25th.
It will also. What's a regular bail application is a plain lady man. He's behind the bar for it. People find the FIR is number 11. She was my husband. It was as per our instruction, a natural death, my lord. Frequently, my lord, son-in-law, in order to the motion my husband. Sir, I making the
How many days?
89 days.
My lord, his case, my lord, only investigation could not be completed because, my lord, due to pendency of the FSL report. My lord. So I am praying for, my lord, since there is the, my lord, 89 days, my lord, there are one more days is left. Let the matter may come up day after tomorrow, my lord. If they could not produce the FSL report, my lordship may get, my lord, default.
No, it's not a question of procuring FSL
Because, my
report.
lord,
It's a
there are
question of
sufficient
filing
materials in the
charge
case
sheet.
diary, my lord. As far as materials are concerned, my lord, she has killed her husband, my lord, with his boyfriend, my lord.
Oh, no, man.
There are sufficient materials, my lord.
False allegation.
I can produce the case diary, my lord, but since there is 89 days, my lord, I am praying to fix the matter day after tomorrow, my lord.
Considering the case diary,
So today he is not, she is not entitled to get default bill.
no, I am not.
If
paying,
lordship
I
can,
am-
if
I am-
lordship peruse the case diary and dispose of, my lord, that I do not have any objection.
I am on the bank
As
for
far as the
detention,
materials are concerned, my lord, there are sufficient materials collected by the IO as on that.
All right, then give the case diary. Why should we fix
Yes,
it
my
again?
lord, yes, lordship may peruse the case.
Before that, you will find the page number 11 is my page number 11. Sir, the above name accused number 1. The wife of my deceased brother Imran Hussain. The accused number 2 was employed as the driver of my said brother. The other accused person belonged to the paternal house of the accused number 1. So these persons were already granted bail. It has come to our knowledge that accused number 1 and the accused number 2 were involved in an illicit love affair for some time, which is evident from WhatsApp chat records recovered from the mobile phone of accused number 2. From these chats, it is also revealed that the said accused person had been conspiring to kill my brother by deceit. Further, it has come to light that accused persons misappropriated an amount of approximately rupees 20 lakhs from the house.
Yes, we have read the affair just on 14th. Okay, we'll see the CD then. Pass it over. Hard learned counsel for the petition. Learned additional people. The CD has been, CDS call for has been received and furnished. Is the matter. Tomorrow Khalid did it for order. We'll pass the order tomorrow.
My objection may be recorded, my lord, because there are sufficient materials collected by the IO. Only investigation could not be completed, my lord, due to non-collective FS. Postmortem report is there.
What time you, my lord? Tomorrow, my lord. Oblige.
Yes, but Madam, my lord, same report was also called for and FSL was also called for.
Accused is the
Allegation-
husband, my lord. The husband, my lord. Wife died, my lord. Some mysterious circumstances, my lord. The FSL report is yet to collect. My
The hospital, my lord. Only allegation is that, my lord.
All right, FSL report not yet received.
Yes, my lord.
Please
Interim
again,
order,
interim order passed.
lord. Call for the up-to-date case diary, my lord.
All right, after.
512 with this.
CD is with you now. CD is with you now.
Yes, yes.
Send back the CD for resubmission in updated form.
interim may be continued.
Yes, yes. Interim to-
Plus. Date,
512.
plus.
Hmm?
27 case diary not.
Same order. There is not
912.
received. Interim to continue.
Then, my lord, case diary not.
Same order.
Interim may be
Yes.
812. Potato, my lord, search is submitted.
So appear there.
Interim is there, lord. Otherwise, it is a student, lord. He on Kazim was arrested subsequently on phone call and in the CTR
So what do you want now? Can it be absolute?
case number 7. Then, lord.
Absolute because charge sheet has been submitted.
His lordship
Eh?
and appear
You appear and apply.
someone with the lordship. Otherwise, right now, lordship cannot say the
No,
my
you
name is
you can appear and apply for regular bail. Till then you can be protected. That is all. Otherwise, we'll call and decide here.
lordship.
You have appeared before the IO.
Lordship, I appear. My student has- Apparently, lordship, my name is FR. My cousin brother who was arrested. Yet after arrested, he called me. Arrested. CTR
He is
called-
named in the charge sheet. Oh, you don't have it.
My lord.
Charge sheet, he may or may not be named also.
FR.
32. My lord, it is not mentioned, my lord, the name of the accused person in the search. Only search sheet number and date is provided. 209.
So we cannot say as of today that charge sheet has been submitted against him.
Lord, same copy may
better because if it is, he is not mentioned, then saying that he will appear
Yes.
and file meaningless. It is submitted, the charge sheet has been submitted in the present case by charge sheet number so and so, but it is not known whether the present petitioner has been named as an accused therein. Hence call for the scanned copy of the PCR
Along with the case diary.
along with the case diary. On
10-12.
interim order passed earlier to continue.
Publish. What time being and this has come. Has come.
It is there, my lord. Let it be on Friday or
Place the matter on Friday. None appears for the petition.
Thirty-seven and 39, my lord. 37 and 39, my lord, may be taken up together.
39 also. Yes. Oh, that true garlanding case again.
page 10.
Did he has come?
Case diary has come, my lord, along with the medical report, my lord. As per the medical report, my lord, the injury is, my lord, simple, my lord. Full injury, my lord. But, my lord, whether accused person, my lord, pursuant to the interim direction, whether they have appeared before the IO or not, that is not clear from the case.
7.
I don't think we should keep this pending again.
Give it to Lordship.
Order dated 29/10/25. Era 1, 2, 3. Charge sheet as CDS called for has been received, and it is submitted by Learned Channel that the nature of the injuries are simple. Further, it is submitted that by Learned Counsel for the petitioners that pursuant to interim protection granted by this court, the petitioner appeared before the IO, and their statements were recorded. But interim protection was there. Having regard to the above, prayer for pre-arrest bail is the order of interim pre-arrest bail dated 29/10/25 hereby made absolute, subject to the conditions that here 403 to deliver. This is 37. In 39, since, whether you appeared, no.
Because there was no direction to appear. Observe that they will appear as and when required.
All right. In 39, line to cut it, that and to interim protection, they appeared before the IO. Line to cut it.
Pablo High Court.
Item number
What happened? 36.
Yes.
Anyway, 36, I think TD was not available, huh? TD was received.
36.
6.
Yes, 36 CD received.
I think somebody else appeared.
No, nobody appeared, my lord. Only public prosecutor.
Yes, yes.
After some time.
We can take it up today.
Yes, ma'am.
I'm sorry, Lordship. The case diary was called for Lordship. FIR allegation says that some called on this person went to one person house. They are the
Medical
villager-
report is there.
Villager gathered there and consulted on them. Such a one driver of the vehicle, he got injured and some were to that the allegation for the FIR. Here we are, 6 persons are there, Lordship.
Your name is?
No, 6 persons are here, Lordship. Tofikul Ali is here, Alex Khan, Jitul Ali, Rahul Ali, Bahar Ali, Moinul Ali, and
All are in the
Nazrul
present petition.
Ali.
All are in the present petition.
Lordship. 6 persons. The entire villager came out, Lordship. The FIR will say, Lordship, they have went to one house person, then seeing them, one person jump in the phone, and thereafter the everything started, Lordship.
Yes, PP.
We are present there, Lordship, being villager, Lordship. In the assault part, Lordship, we deny that part.
The victim has implicated all the accused persons, my lord. The injury report, my lord, is face, my lord. Face injury, my lord, and object is blunt object. So it is grievous or simple, that is not clarified.
Imdadul Ali. Injured?
Lordship.
Yes, my lord. Imdad Ali, my lord. He is a police person.
Driver of the. Lordship, as per our, we have witnessed that.
During their official duty, my lord, they were assaulted.
It was not grievous one, Lordship. All villagers gathered there, Lordship. Among them, we are also there. Regarding assault part, we did. Because of that incident, Lordship, the entire villager came out from their house and.
No, have the accused persons been named specifically? That
Yes, ma'am. He has implicated all the accused persons. Fikul Ali, Rohan Ali, Ratul Ali, Bahar Ali, Kazrul Ali, Moinal Ali, Tu Ali. ma'am.
And what did you say? The injury report said?
Injury report, my lord, simple and my lord, face.
That means not grievous.
That we cannot.
No, if it is simple, it cannot be grievous.
Injury was there, Lord.
It should be, my lord, grievous or simple, my lord. The face injury, my lord, what does it the doctor? It's very difficult for us, my lord, to face the injury.
No, fresh means whatever it means, it is recent.
That is
All right,
Any
hard.
condition, Lordship.
The prisoner. Turning this 50. Actually, it's very, FIR is a little difficult to understand. Somebody ran away and jumped into a pond. He was rescued.
Looking them, Lordship, they says him, Lordship.
Then they attacked.
That is why people came out from Lordship nearby, Lordship. The other out of the record, some different issue is there, Lordship, that cannot submit in the court. For their from them, Lordship, they running, he ran away and jumped in the pond and they assaulted him. That is why please style, Lordship.
The allegations as reflected in the FIR is that while the police personnel of Doboka police outpost were on patrolling duty, they saw a person running and jumping into a pond, whereafter he was rescued by the police patrol party. But the accused persons, along with other villagers, attacked the police party with lathi and rod, etc., and assaulted the driver, Imdadul Ali, because of which he sustained grievous cut injury on his head. On perusal of the CD, learned 50 submits that the injuries have been indicated as fresh and simple. So, however, learned additional PP opposes the pre-arrest bail on the ground that the accused person assaulted police personnel on duty, and the victim has also implicated them. In regard to the fact that only simple injuries have been. How many injuries? One injury or anything indicated?
Injury, my lord, but a medical report, my lord. One is my lord, the scalp, my lord, abrasion, my lord, the scalp, and other injuries, my lord, elbow joint and right knee, my lord.
Abrasion.
Top tissue scratch, my lord. Abrasion in the, my lord, scalp.
To the fact that the medical report reveals only abrasion on the scalp and soft tissue injury on the elbow. It
Top
could
tissue
not
scratch, left elbow and right knee.
elbow and right knee.
Right knee.
Soft tissue injury on the elbow and right knee. I am of the view that it would not be necessary to take the petitioner's custody for the purpose of investigation. Accordingly, pre-arrest is about 3,000 years subject to the condition. This can appear before the period of 7 days. Cooperative time.
Much obliged, your lord. Much obliged. Much.
Case that is, my
Please, and
NDPS.
my lord. Case, theft in bank, my lord. One person must enter into the bank, my lord, the bag of the informant, my lord.
Oh. Yes, PP.
I have, they are from West Bengal. At that point of time, we are not.
CCTV footage is there, so
No, my lord, that
it
is
will not be difficult.
my lord, in this case, in this case, my lord, I have found only, my lord, two witnesses, my lord, examined by the IOM. One is the informant, my lord, and other person is the, my lord, driver of the vehicle. Now, my lord, they were, my lord, stars on the basis of, my lord, the CCTV footage, my lord, but there is a note of the investigating officer, my lord, that Lord, can I kindly peruse.
You can tell us. Didn't- All right.
It was only, my lord, the as party the CCTV footage only one person. That we hear from and they were, my lord, arrested in some other NDPS case, my lord. And but this case, my lord, they were application was filed to on them arrest, my lord. But that was rejected because 47 and 48 notice was not complied with. After that, my lord, no application has been filed. They filed another application by the IO. Her sole errors was rejected. Her sole errors application was rejected. Because, my lord,
What is violation of 47?
yes, violation of, my lord, for 47. 48
Thereafter,
was,
what happened?
my lord.
Thereafter, what happened?
Thereafter, my lord, the IO should have filed another application, my lord.
Then how was he shown arrested?
So now, my lord, it is not clear whether they were shown errors or not.
Huh? Oh, this is AB.
This is AB, my lord.
They have not made further prayer. Once, like earlier case, they were arrested. That's why they.
Otherwise, there is no identification.
Not clear, my lord. That is why I placed the case diary before you. Only two witnesses were examined, my lord, by the IO. They should have examined, my lord, the bank officials, my lord, bank security guards.
Had heard from counsel for the petitioner. And additional PP. The allegation, this is an application under students. The allegations as contained in the FIR is that the informant along with his driver had gone to PNB Nagaon branch where his driver dropped him and he went inside the bank with his bag containing rupees 45 lakhs and he had kept the state bag on a steel chair near the counter and at about 12:34 p.m. one unknown youth wearing black pant and white full sleeve shirt snatched his bag and fled. Full stop. It appears from the CD that the IO has examined only two witnesses and the contents of the CCTV footage is also not reflected in the CD. The petitioners were arrested in connection with another case being, which case was that?
218
When was that arrest?
It is after the incident, my lord.
After the incident?
Yes. But
Which
this
took place
FIR
after
is
the,
of, my lord,
which
May
took place after the
2024, my
present
lord.
incident?
It was
Which took place, were arrested in the so and so case after the present incident. And prayer was made to the magistrate for known arrest of the present petitioners in the present case, which prayer, however, was rejected due to violation of section 47/48 BNSS. However, it appears that no fresh prayer for showing them arrested in the present case has been made by the IO. Therefore, from the available material, there appears to be no direct implication of the present petitioners in the instant case. Considering the same, prayer for pre-arrest bail is allowed. 50,000 to zero.
They may be directed to appear before the IO within 10 days.
In that case, they have got bail.
yes, ma'am.
That also you mentioned.
Got bail on 27/10. PA number 33.
Another case. He did.
Test order dated 7/10.
The condition deliver 7 days. Cooperate with the investigation.
That means 10 days.
10 days. Okay.
Obliged, ma'am.
Can back the CD.
Present.
Yes.
Where is it? That some person formed a railway union fraudulently collected money from person. But against the petitioner is that, my lord, I am the only executive, my lord. Page number 14, my lord. Only there are other members, there are other allegations against other members, but against me, police say that I am the executive. Other
What is your name?
my lord, my name is my lord Biswajit Soikia and my lord Purno Bodol.
Yes, PP, any specific material against them?
The main accused was arrested, my lord. He reveals that he is the member of the association, my lord, and the association by the collected the money and they are divided the, my lord, amount collected with them. Financial benefits, all the members are getting the funds. Specific allegation against the Dhon Kumar Deka, my lord. He was arrested and he was granted under regular bail.
As against present Biswajit Soikia and
He is the member of the state executive of the committee, my lord.
he may be a member, but
But there is no specific, my lord. The person arrested who has already been arrested or the person who has, my lord.
he said that he is a member.
My lord.
Beyond that, what is the
There's nothing.
that you submitted something about the money
Money,
collection?
my lord. They have collected the money. They are providing the QR code to the persons, my lord, and they are collecting money from the persons, and they are utilizing the money and the financial benefits. All the members are getting the financial.
But not specifically this Biswajit
But
Soikia.
he has collected the money. That specific allegation, but no statement was there. But the statement was there, CCTV footage was there. The person who collected the money, my lord, that is the Dhan Kumar Deka, my lord, he collected the money from various persons, providing he is the zonal president, and he's providing the QR code to the persons who was enrolled as a member of the committee, and they're collecting the huge amount of money they were collected from the different persons on the pretexts of providing job in the Indian Railway. And they have the car, the nameplate is there, Indian Railway, Bharatiya Railway, like that way, and they are themselves, they're putting that they are the members of the Indian Railway and they're collecting the amount. These are the allegations, accusation. And he is one of the state executive members.
It is a, whether any, what is the status of this organization? Allegation is that it is a fake
It's a
organization.
fake organization. My lord, there is no, that organization is not a recognized organization of the most.
So definitely they must be beneficiaries.
Yes, they are the beneficiaries, my lord. As the state executive members, is the also beneficiary.
FIR, no allegation.
You are part of the scam. You are the member of an association, unrecognized association, fake association. You have been collecting money in the name of jobs. So their custodial interrogation may be necessary.
My lord. And all the photographs and all these things are there, my lord. Yeah. They have used the car, my lord. They're putting the red, my lord, nameplate like that. Yeah, my lord, Indian Railway. Vice President, Plumding, so-and-so, Bharatiya Rail, so-and-so. And using the car for collecting the money.
Both you see
Regular bail or pre-arrest bail?
previous bail.
Hmm?
Previous bail.
Where is that?
After some time.
You have.
But in the case, that number is also, that is, I think it is listed also 2152 also.
Huh?
2152.
If they have been granted, why is it listed?
Because this another number is there. Both the cases were earlier listed together, my Chandra Kolita. It was granted interim bail and statement was recorded. So thereafter interim bail was confirmed.
But in this case, interim bail is not
No
there.
interim.
So they must have appeared.
My lord, his statement was not there, but
my
whether
lord,
his statement was,
My lord, here, according to my instruction, he went to record his statement,
his statement was not
but
there.
his statement was not,
But his statement is not there. So
statement was not recorded.
but there's a condition, I think it should be, my lord, so his statement should be recorded, my lord.
Not recorded, my lord. He went there.
Direction is for him to appear.
File.
If he appears and his statement is not recorded for
My lord.
whatever reason, what is he supposed to do?
My lord, it reveals that his statement is not there. Statement is not there. So it presumes that he did not appear before the IO, my lord, for recording his statement.
All right, why should the presumption be always in favor of the IO?
No, yeah, no, yeah.
What
It
if
is
you
not the
had-
presumption, my lord?
What if
If
you
the
had gone for
person-
VIP
if the
duty?
person, my lord, appeared before the, my lord, IO, then definitely his statement will be recorded there, my lord.
No,
Case
we have
by-
seen cases where it was not recorded, IO on VIP
But in-
duty,
In this particular case,
IO on
my lord,
security duty.
my lord, in this particular case, if he appears, my lord, he has to submit the bail bond or like that, his statement should be recorded. The condition should be there. And he has not made a statement before this court by way of additional affidavit that he went on particular date. That is only the verbal statement, my lord.
Okay, we'll issue a direction to the IO to record his statements.
My lord, my lord. That's
Will not dispose of the matter.
my lord.
It is submitted on behalf of the petitioner that pursuant to order dated 23/10/25, the whereby petitioners were directed to appear before the IO within 7 days, the petitioners had gone to the police station. He had gone to the police station.
date, my lord, on particular date, he went, that statement is not, your lordship. That he went on a particular
All
date,
right,
my lord.
let's not delay the matter.
My lord.
But for whatever reason, their statements were not recorded.
Recorded.
Hence, the IO is directed to record their statements. Can you speak a specific
Specific date, my lord, he should appear within 10 days or 7 days
Yeah.
like that. Way statement.
upon appearance of the petitioners within a period of another 7 days from today? And submit the report in this regard. CD, send it back.
Return, my lord.
Huh?
Return, my
Send back the CD for resubmission along with the statements of the petitioners, if so recorded. List again after a week they did it. After 10 days, the interim order passed earlier to continue till the next. And what about this one? Is nahi. Correction. All right, will pass over. But a correction is a final.
Thereafter, it came to the knowledge that the respondent caused the complaint. He expired, lordship.
Pardon?
Yes, lordship. Complaint, respondent who lost the complaint case for CM Bongaigaon. I think come to knowledge of the petitioner that the respondent who expired. That is my decision, lordship. The complaint case is regarding that some allegation regarding 294 and 54. I am getting complaint report and a report from the OC Bongaigaon. To inquire the report, submit report, lordship. Page 40 is the report, lordship, from OC Bongaigaon. Page 40 of my complaint. There is no allegation regarding 94 and 54, lordship. Page 40. Report submitted by the inspector of police.
So what is to be done now?
Now, lordship, as the complainant complainant already no more, lordship. Direction given to the trial court matter because of law or necessary order. Additional affidavit, I accept lordship, page 45. Death certificate of the complaint. Police reporter was saying that there is no incidents like that. Page 40 of my complaint case. I am master by profession. Also against a fire. So that was not they're going to speak from court on the report from the OC concerned. Submitted that there is no such allegation. Page 40 of the
Complainant was already examined earlier.
yes, Lord. Page 29. Lord. Then was given direction, submit a report, Lord.
then OC submit a report, page 40. So, OC reveals that there is no such an incident. Last paragraph, page 40.
So the case anyway cannot proceed otherwise. The
Yes, Lordship.
cross-examination hasn't taken place.
President died, Lord.
All right, we'll just direct. Order dated 10/5/24. Okay. Paragraph 1, 2, 3. Four. Just up to petitioner, okay, on page, the reverse page, first two words, to that only. An additional affidavit has been filed by the petitioner stating that the complainant had expired long ago and has also annexed a copy of the death certificate of the respondent number 2, which is marked as Annexure E. Wherefrom it appears that the complainant Kana Chanda, K-A-N-A-H-A-N-D-A, expired on 23/7/2024. Hence, as prayed for by learned counsel, the present petition is closed with a direction to the
SDGM Bongaigaon.
SDGM Bongaigaon to pass necessary orders as per law.
Here case number 280,
In your case number
288 of 20. Next.
I've heard this before, I think.
Yes, Lord. Started on last week.
I think prosecution part is to be heard. Are you ready today?
Yes, Lord.
We'll take it up. You can. Yes, next.
Lordship, in this case, interlocutory application for Lordship. Accused appellant was convicted.
Respondent number 2, you have appeared. Any objection?
Yes.
Huh?
No objection, Lord.
You have filed.
Yeah, affidavit is not filed, Lord. Court authority filed.
Uh-huh.
Respondent number 1 file of it.
State has filed.
Lordship, state filed. I have received.
You don't want to file.
Lordship already 5 years old.
Yes, not completed.
Huh?
Not completed, Lord.
5 years not completed.
Month short, Lordship. So considering this aspect, and otherwise, Lordship, kindly have a look at the evidence of the victim, Lordship. Azahar lost after 8 months, Lordship. After 8 months of the occurrence, Azahar lost. And statement of the victim, Lordship, kindly have it.
Yes, what is your objection?
Lordship, we have already filed our objection. Victim is the star witness. Her state's testimony found to be trustworthy, Lordship, all along in her 161, 164 statement, as well as before the trial court. So kindly come to the victim statement, that is PW1. And her statement is also supported by the medical evidence. Happens to be the doctor PW3 lot. She is a minor, there is no controversy, and that is unchallenged. The date of birth is below 10 years. There is a forceful commission of rape upon her while she was going on her
FIR was lost 7 months or 8 months later because by that time pregnancy had become apparent.
pregnancy. You see, her mother was pregnant and her father used to stay outside, is in Kerala.
But
That is
she
the only
was-
reason. So
she was
that
residing in the
cannot
house
be a
of the
ground for
accused person. Lord.
that cannot be a ground to demolish the entire prosecution case only because of the tactic. Victim statement, when the victim statement is found to be trustworthy,
And the Lordship,
consistent,
kindly have a look at
and
the evidence of
truthful, Lordship.
IO Lord. In her 161 statement, whatever she stated before the trial court was not stated before.
161 is not
Not
covered.
stated before the
164 and that is
There is a
corroborated
improvement.
with her evidence before the trial.
If you want, we can have hear the matter finally on a hearing date.
Lordship, that
I am at this stage, I am just pressing a bail, Lordship. Already 5 hours are, Lordship. That part, considering that aspect, and Lordship, that event, 4:30 will come, Lordship.
You are convicted.
yes.
Lordship, convicted.
How will 436 come?
But appeal is a continuation of the trial, Lordship.
So you are an under trial now.
Lordship. Yes.
Okay, let us see. We'll see the record. We may either decide the IA or we may say that.
Lordship,
It's
Lordship, at
considered.
this stage, I am not ready for other aspects.
No. If we don't decide the IA, we will say that we'll hear the entire matter. If I can find some apparent, because we can't go in the IA, we can't go deeply into the evidence. If
Sure.
there is something glaring,
Yeah.
then
And Lordship,
that time we
one
can
aspect
say.
I submit, Lordship, there is a delay in lodging FIR that was not explained. Almost after 9 months, victim stayed with the accused for a last during that period, and thereafter she returned back, and then Azahal. There is a marriage.
Where did she go?
He was with the accused. There is a marriage solemnized between the parties.
That was
But
forceful.
subsequently, he denied that that was a forceful marriage.
Forceful
Is
marriage.
it possible, Lordship? He stayed for 8 months the house of the accused.
She is a minor, Lordship.
But no such Lordship age proof document was not given.
But that point was not challenged by the defense counsel at the time of cross-examination. That is PW1, PW2.
That was
Nothing, Lordship, nothing was.
Lordship, age was not proved. My submission is that age was not, delay was not properly explained.
Her age
And
is not
victim was
challenged during the
victim
time
was
of
with the
evidence,
accused
Lordship.
for 8 months.
Her age is not challenged during the time of PW1, PW2, victim, mother, comment was cross-examined, including 4 and 5. Happens to be the independent.
Yes.
Other way also, Lordship. When the victim is minor,
Lordship,
which is remained unchallenged, concerning her age of minority. Oh, her consent is no consent before the eyes of Section 25, 29 and 30 of POCSO Act will come into play if the foundational facts of the prosecution is established on preponderance of probability. lot of judgments.
All right.
Lordship, will hear the matter.
No, we have heard. I said that we'll pass orders on the IA. We may either decide the IA or we might say that we'll hear it.
Yes.
We'll hear the matter
Final
finally.
hearing.
So either of this can happen.
Lordship, may I give some judgments?
Yes.
Regarding PSP case correction number, I was in court number 9.
Oh, I think you have stated what correction is regarding,
Yes.
only case number.
I will.
All right.
North Guwahati case is 76 million.
What was this?
This, whether search has been filed or not.
Oh.
Instruction was sought for.
Okay.
Accordingly, we have got the telephone. Case is pending.
Okay. So we are on merits now.
Today is the, as on today, Lordship, it is 89 day, Lordship. Accused are in custody.
Go to the. No, you have to call for the
Scan copy.
copy.
Since today is 89 days, case is still not submitted.
Not submitted.
Not submitted.
Oh, I thought it was
What
submitted.
she meant was that is pending,
Is pending.
pending for.
Oh. Yes. And what is to be done now?
Is
Just paid down. During
Can still reject it because we rejected it earlier.
Lordship.
We have to decide on merit.
as on today, Lordship, they have been thoroughly interrogated persons. They were not present at the place of occurrence.
Let us do one thing. We'll take it up day after tomorrow. Let it be completed. Please take it on.
Publish.
Get the instruction tomorrow also. Whether it is submitted.
If this application has referred again, referred it 27,005, that it has through an extra $6. Whereby the rejected by the learned court. Mary,
Yes.
the matter was fixed for Zimmer report from the IO hearing.
Page.
Page 62, your extra 6.
Yes.
The matter was for Zimmer report from the IO and hearing the Zimmer. Petitioner is represented by heard report as called for is from to concern. Peruse the same wherein it is stated that he sees vehicle bearing registration for the as the investigation is in progress. The owner of the vehicle is owner. The Zimmer actual of the vehicle. Peruse the case record considering the report of IO. The Zimmer petition stands rejected. Petition number so and so is goes of according. Your Lordship, the Zimmer petition has been heard by the finance two-wheeler vehicle. Now, registered owner of the vehicle is represented by Learned. Vehicle is lying before 2024. In fact, the concerned person, the victim, he died in the said incident for that the FIR has been lost. Moreover, the charge sheet has been filed, the trial has already commenced, is registered as PRC number 44 of 2025. Since January, they have not been paying monthly EMIs and under loss because of paid vehicle.
You are the finance company.
I'm the finance. The finance amount of 8,000. The EMI comes around 5,000.
What is the stage of the investigation now?
Investigation is complete because Lordship,
Charge sheet filed.
PRC case number 44 of 2025. Trial has commenced. Trial is going on.
So you are the owner.
Yes.
Yes. What is the submission?
I am the owner, and I am the murder of the victim, Lordship, and my son was brutally murdered by some other people, Lordship, and thereafter the vehicle is seized by the police and it is lying on the police station. I have no objection if the vehicle is handed over to them, but Lordship, I am unable to pay the monthly installment. There is no one to ride the bike, Lordship, and I am the mother, Lordship.
We are not concerned with that part in this
Yeah.
revision.
Check your Lordship, get the custody, go for auction of the vehicle. Whatever amounts is collected after auction, the remaining amount that can be settled in both the parties.
That is up to.
It's up to the finance company and
But then is of 225 submitted. Yes, I think better if we call for a report from the IO. Right. So the vehicle was was involved in the incident itself.
Yes.
yes. The person expired, he was riding that particular vehicle.
He was murdered.
He was murdered. For that, Rongya PS case number 3 of 2004 was subsequently charge sheet filed. Now it's for the session just Rongya 44 of 2000.
If they can waive the EMI, I have no. There is none to earn.
They will waive the EMI. They will sell the vehicle and give you the remainder after deducting their EMI.
The EMI and
And waive the EMI means you don't have to pay. They will deduct it from their sale proceeds anyway. But we are not going into all that. All right. Third learned counsel for the petitioner, counsel for the private respondent. By order dated 27/2/25, the prayer for Zimma of the vehicle was rejected by the learned court below. As in view of the report of the IO that the vehicle is required for investigation, which was in progress. It appears that charge sheet has already been submitted in the case, hence the investigation is over. And therefore it is the reason earlier shown by the IO no longer appears to be valid. Instead of calling for a report, we will say that you will file fresh application before the court below, since investigation is over. Longer valid. Hence, this instant revision is disposed of with the observation that the petitioner shall file a fresh application for Jimma, may file a fresh application for Jimma of the vehicle in question, which shall be considered by the learned court below, keeping in view the law laid down in this regard by the Honorable Supreme Court as well as High Court. Accordingly, the revision petition stands disposed of the said observation.
But to item number 4, which we have to close, have instruction, Lordship.
Withdraw.
Item number 4.
Item number 4 as prayed for by learned counsel for the petitioner, Mr. So and so. Matter is dismissed as withdrawn.
My lord, the second time application, my lord, today, my lord, 23 days custody. Charge sheet has not been filed.
Not filed.
Not-
Learned counsel for the petitioner. Learned additional PP on instructions received submits that charge sheet has not been submitted as yet. Full stop. The petitioner has already crossed the statutory period of detention of 90 days. And hence he is entitled to default bail. Accordingly, it is directed that the petitioner shall be released on bail of rupees 50,000 with one surety in connection to the satisfaction of the learned
SDGM leadership.
in connection with the effort.
Development.
It stands allowed accordingly. Five. Five. Is 46.
Here, the applicant was convicted under section 6 of POXO Act, Lordship, for 10 years. And he is in custody for about 4 years. And today this matter has come up for
Wherein, my lord, the appellant was convicted under 10 years. But I have already made my sub
Yes.
part. It was for by the
Yes.
So, it's taking basically 3 points, my lord. On the section 42, my lord, has not been complied with. Regarding section 42, may I take your lordship to paragraph number 31 of the, my lord, judgment. Parbook. That would paragraph 31, my lord, that in our place is 42, my lord. The memo we appeal. Section 42 NDPS Act. can be-
Judgment. Judgment.
Judgment, my
Yes, para.
para 31.
Paper book is there.
paper book.
Not there. What is the sentence? 10 years.
10 years.
Up to 10 years, we don't need paper book. Above 10 years.
It's up to the
Lordship convenient.
Hmm?
What is honorable court convenient?
All right. We'll too late in the day now. Yes, para 31.
Para 31, my lord. Section 42 NDPS Act can be divided into 2 different parts. First is the power of entry, search, seizure, arrest without warrant or authorization as contemplated under section 1 of the state section. Second is reporting of the information, reduced writing to a higher officer in consonance with subsection of section of the section. Now, my lord, if one case, my lord, suppose is a mother son's recovery, my lord, then my lord, after the my lord, seizure has been met, my lord, it can be reported. And second part is that, my lord, the prior information is there, my lord, then my lord, inform his superior officer, my lord, then my lord, order was made, my lord. Go ahead with the search and seizure, my lord. Then, my lord, section 42, the second part. Subsection 2 of section 42 had been a matter of judicial interpretation as well as of legislative concern in the past. Subsection 2 was amended by Parliament by Act 9 of 2001 with effect from 2/10/2001. After amendment of this subsection, the word forthwith stood amended by the words with 72 hours. That means, my lord, if the information, suppose without the prior information, my lord, suppose the search and seizure has been made, then, my lord, within 72 hours, my lord, he has to inform. So, an absolute certainty was brought in by binding the officer concerned to send the intimation, the superior officer 72 hours from the time of receipt of information. It provides a greater certainty the time in which the action should be taken, as well as renders the safeguards provided when accused more meaningful. Now we have to see if in the instant case there is substantial compliance of section 42 or not. Paragraph 32. As per evidence of PW1, the content of GD entry was not communicated to the superior authority in writing, but by Exhibit P4, PW1, he communicated in writing to superior authority regarding the compliance of section 42 of the NDPS Act. Then it can be seen that PW1 who received the secret information in the instant case and communicated the same to Deputy SP Headquarters Dhubri by the Exhibit P4. In the said communication, he has also mentioned about the reference of Sagolia OP GD entry number so and so dated so and so, which is also duly exhibited as Exhibit P1 PW1. Upon further perusal of the said GD entry, it can be observed that all the relevant details about the secret information received by PW1 was from over phone to various authorities, including SP Dhubri, who in turn instructed PW1 to acquire authority letter from FTSP Headquarters Dhubri, which was duly acquired by PW1 from Shankar Mandal, Deputy SP Headquarters Dhubri. The said authority letter is duly exhibited as Exhibit P3 PW1. Provision of section 42 of the NDPS Act to inform the superior authority in writing about the details of secret information and other relevant details to the superior authority in order to rule out any concocted case made against the accused person. In the instant case, the reference of GD entry number 194 dated 11/4/2023 is specifically mentioned as the Exhibit P4 PW1. While communicating the information to the superior authority by PW1, it gives the information to the extent that GD entry number 194 dated 11/4/2023 is duly met in connection with the instant case. Exhibit P4 PW1 was communicated to the superior authority on 11/4/2023, that is on the same day of the incident. Therefore, I am of the opinion that there is substantial compliance of section 42 of the NDPS Act. As far as NDPS Act, my lord, how it was informed to the superior authority, my lord, and under what circumstances, my lord, the permission was obtained, my lord, it is clarified in paragraph 32 of the judgment. Now, my lord, second, my lord, his second contention was that, my lord, only VDP officials were, my lord, examined, my lord, apart from the other. In this aspect, my lord, I'll take your lordship to paragraph 26 of the judgment, my lord. In the instant case, no doubt, all the three seizure witnesses belong to VDP, who may be under some administrative control of Superintendent of Police Dhubri. However, it is required to be kept in mind that on many occasions, civil witnesses and neighbors are reluctant to give their consent during the search and seizure operation. A seizure witness, for various reasons, including one of developing the enmity between them and the family members of the accused. Moreover, there is no law that that the evidence of police officer or BDP, unless supported by independent witness, is to be discarded and or unworthy of acceptance. There is no allegation of any enmity between the BDP and the accused. No such defense has been taken in the statement under section 313 CRPC. The evidence of BDP cannot be distrust and disbelief merely on account of their official status. So from the overall appreciation of the evidence of all the witnesses, I am of the considered opinion that their evidence inspired confidence of the court. Only the GDP and GP, my lord, witnesses, they were made the Caesar witness, my lord. So that is the minor point taken by my learned friend, my lord. Secondly, my lord, there was my lord, argument that, my lord, that FSL examination, FSL person who conduct the FSL, my lord, was not examined. In this case, my lord, I'll take your lordship to the, my lord, TCR, my lord. May peruse the TCR, my lord, there is an order dated 25/6/2024, my lord. There is an orange flag, orange color flag, the TCR.
Yes.
This is the order dated 25/6/2024, my lord. So on that date, my lord, the defense, my lord, the accused person, they filed an application, my lord. They said that only the FSL report may be considered in connection with this case, my lord. And if my lord, the person who given the FSL or who has made the examination, if he is not examined also, my lord, they do not have any objection, my lord. So they want to, my lord, post the evidence, my lord. So in this regard, my lord, findings are at paragraph 33 of the judgment, my lord. Paragraph 33, page number 44, my lord. So now, since they have taken a plea, my lord, before the trial court, my lord, without examining the FSL report, my lord, now they cannot take this, my lord, court is honorable. The FSL report is the person who conducted the FSL examination not examined. So that is their prayer, my lord, not to examine the, my lord, person who conducted the FSL. Now, para 33, my lord. As far the FSL report is concerned, it can be seen that by petition number 670 dated 25/6/2024, learned defense counsel has stated that the evidence of forensic expert is not vital and the content of FSL may be accepted, because the application was filed for the trial court, on that day. As per the FSL report dated 31/5/2023 rendered by Sri Syam Goswami, Senior Scientific Assistant Drugs and Narcotics Division, Director of Forensic Science, Assam, gave positive test for codeine, presence of codeine phosphate, and the amount of codeine phosphate was found to be 180.1 mg. It is to be mentioned here that as per section 293(1) CRPC, the report of the expert can be accepted evidence by the court. So, my lord, these are the, my lord, three grounds, my lord, they have argued, my lord, by placing this appeal, my lord. So, my lord, there I have gone through the entire evidence of the, my lord, prosecutor witnesses. There is no infirmity, my lord. The contraband was, my lord, commercial in nature, my lord, was seized from his possession, my lord. So, my lord, judgment and order that is passed by the learned trial court, my lord, that may be upheld, my lord.
Yes. Reply.
Once, and I'll then
Mhm.
bullet points.
Once what?
The bullet points of our argument.
Yes, you can submit.
Yes.
When?
By tomorrow morning, my
All right. We'll CAV now.
file. Highly obliged.
add করে দিব। Six to what is this? How many CAVs can we do in a day?
Yes, last order, Lordship, kindly available.
Huh?
Applicant before your Lordship, without going to the merit of the case, just paying for my set off, my lord, the period undergone very much.
Yes, yes. There was something supposed to be submitted today.
Yes, sir. Page, my lord, 190.
Yes, confinement in observation home and yes.
I am for the information.
Yes, any information you have you gathered?
Lordship, first of all, Lordship, my respectful submission, Lordship. My learned friend is trying to convert, Lordship, the earlier period of,
Yes, that we know. You were
Lordship,
supposed to.
but in that respect, my respectful submission, Lordship, as per section, he was never in jail, Lordship. He was in reformative.
No, that was your submission earlier also. We
Lordship.
wanted to know what is the distinction.
Yes, Lordship. This distinction, Lordship, I am just coming, Lordship, of the definition.
As per Act, my lord, there is no issue.
There
It's
is
or like that.
Lordship. 246, Lordship, of the JJ Act, Juvenile Justice Act 2015, Lordship, page 8.
Yes, JJ Act.
Lordship.
Yes, you can read. You can
Lordship.
read. You can read.
Supply.
We'll get it by that time.
Place of safety means any place or institution not being a police lockup or jail established separately or attached to an observation home or a special home, as the case may be. The person in charge in which willing to receive or take care of the children alleged or found to be in conflict with law by any order of the board or the children court, both during the inquiry or ongoing rehabilitation after having been found guilty for a period and purposes as specified in the order. My recent submission, Lordship, prior to that reformative home, he was in safe home, Lordship.
This definition you have just read out is of what?
That is Juvenile Justice Care and Protection
Yes,
Children Act
section
15, 46, Lordship.
section 46.
Lordship, 246.
246.
Lordship, 2 of subclause 46, Lordship, section 2, subclause 46.
Say that.
Definition. May I supply the books, Lordship?
We have got the book.
Oh, Lord.
Thank you very much.
And corrected home is now the, as per section, my learned friend, Lordship,
Place of safety means any place or in this. An observation home is 40.
Lordship. And normally I've gone some to net, Lordship, I found the corrective home, Lordship, normally meant for those who are not major. As per
Is there any definition of corrective home? I don't think
corrective
so.
home, Lordship,
No, my lord. There is no such
There is no such provision in the act and we do not have any corrective home. We having observation homes.
Notifications, my lord, clearly given page 40, my lord, section 47, 48, 49, and 47, my lord, observation home, 48, section 48, special home, section 49, place of, and section 50, children's. My lord, as per my-
Let me, Lordship, either my learned friend to argue, Lordship, or
No, no,
to.
I'm
please.
arguing.
Let me clear now. Either you should submit or I.
What other sections you mentioned?
My lord, section 47 is regarding my lord observation home. Section 48, special home. Section 49, my lord,
47. 47 is
Prescribed.
My lord, observe.
main act. Main act. I
Main
mean,
act.
not subsection.
No, I'm just defining purpose of the homes. 47 observation home, 48 special home, 49 place of safety. And as per my lord, my understanding, my lord, where my lord during trial, my investigation, my lord, observation, and etc. My lord, then he used my lord permanent, my lord found convicted. Then my lord he was.
I think we have observation home in Boko.
And in Lordship, earlier he was at Silchar. I think, I don't know. whether he-
Silchar earlier there was no observation home. There was great difficulty in taking the
Hailakandi.
CCLs to not Hailakandi. They had to be taken to Boko at the,
And
about
there
10
is
years back.
Only
At the
reformative.
time
homes
when
are
I
there.
was session judge of Kachar.
Lordship.
That used to be the case. Subsequently, I think near.
Sir, my lord.
Huh?
This is right, but now my lord there is.
Yes.
And as per my lord judgment, it was just my lord mention corrective home. My lord, observation home. Not there is no corrective.
But and normally, Lordship, the my to submission, Lordship, he is claiming the earlier period in the safety home to be reconsidered, Lordship. Normally, 428(2) or 428(1), Lordship, as section 428 of the TRPC that dealt with all these things, Lordship, about the consideration of that period of set of period. And that set of period of 428(1), Lordship, only mean those who are in jail. On that respect, Lordship, I have collected one recent judgment of 2025. I supply the copy of the same, Lordship.
No, no,
Let me,
POXO also my lord shall be applicable.
maybe CRPC is applicable in POSCO, Lordship. That is not the things, Lordship. That is why the learned session judge has not passed the order what my learned friend is saying for now. My lord, paragraph 12, page 6, Lordship, and I relevant portion just to save your Lordship time.
Para 12.
Para 12. May I read, Lordship?
Yes.
Eleven also, Lordship, that discussed about 420. such a heinous crime he was involved, Lordship, information is necessary who may impact the society. He is giving the said benefit of what my learned saying, because he is involved in such a heinous crime. He has admitted that he has committed the same, for which the learned session judge Hailakandi has passed the order for correction of home and report. Report is necessary for about the information. And
In the judgment you have cited, this was not the question.
no, Lordship, just I am coming on that. Whether he is to get the benefit of that remission period of earlier, Lordship. If he is in jail, he should entitle under section 428. So
This was a case dealing with detention in a separate case.
not only separate.
Suppose there are two cases against him.
Lordship.
He has already undergone some detention in one case, whether that detention can be set off in the other case. That was the question
And
involved in this case.
Lordship, but in paragraph 12, Lordship, the discussion on 428, Lordship. Just I am coming, during the stage of investigation, inquiry or trial of a particular case, the prisoner should have been in jail at least for a certain period.
Yes.
So whether this Lordship, this juvenile was in jail or not, Lordship. If he is in jail, he is entitled for the benefit of under section.
Then if he was in an observation home,
Lordship, he was in observation home as per definition, Lordship, that was not in jail.
no.
Jail, Lordship. My respect to submission.
So according to you, he must spend at least some time in jail.
Lordship. So, he
But
is
being a juvenile, he cannot spend any time in jail.
No. He is a juvenile. Once he is a juvenile, he is as per section 9(3), Lordship, of Juvenile Justice Act. That judgment also, Lordship, about the conviction, that part, Lordship, just I am referring also on that also. 9(3). May I read, Lordship? If the court finds that the person has committed an offense and was a child on the date of commission of the such offense, it shall be forwarded to the child, the board, for passing appropriate orders, and the sentence, if any, passed by the court shall be deemed to have no effect.
How is that relevant here?
That means, Lordship, my respectful submission, his part of juvenile justice, Lordship, he cannot be treated like other accused, he cannot be sent for jail, Lordship. And the learned session judge passed an order for keeping him in the reformative home in the judgment of paragraph, Lordship. What the learned court below has observed, Lordship. Paragraph 72. The convict CCL Abdul Kaim Barwai is sent to a corrective home for 7 years for the offense of committing kidnapping for ransom and murder of a deaf and dumb boy, namely Jubair Ahmed Majumdar, and concealing the dead body of a deceased Jubair Ahmed Majumdar under section so and so. And after serving out the sentence, a report be placed before this court regarding the behavior, conduct, and his mental health development during the period of detention, Lordship. Whether, Lordship, my respect to submission, I pray, Lordship, whether he is in that CCL, Lordship, is in developing his behavior, conduct, Lordship, because he has admitted paragraph 69 of the judgment, Lordship. The convict has stated that he has got his parents. He further stated that he has never been convicted by any court and prayed that he may be given a chance to rectify himself. He has been realized his fault. He has been observation home Silchar for last more than 3 years and pleaded for clemency. But the learned court, Lordship, my respect to submission, if any remission is there, Lordship, of the prior, but set up to be considered, Lordship, under section 428, Lordship, of the CRPC, Lordship. In appeal, Lordship, but here in this case, Lordship, it's such a heinous crime, Lordship. If the setup is considered, Lordship, he may commit any other acts what he has committed, Lordship, earlier. such a serious crime he has committed. A thief and dumb boy was murdered, Lordship. Photographs, everything is in the paper book, I think on the record also, original record.
We are on a question, different question right now.
Lordship, please. His age is now
Yes. Question is whether
Lordship.
for 28 it all will be applicable.
Lordship, please.
Just, my lord, I beg to show, my lord, same honorable judge, my lord, the same, my lord, another judgment is passed, my lord, giving the set of benefit, my lord. In, my lord, the page number 107, my lord, it's the IA, my lord, 918. Plus, perhaps, my lord, due to some leak, sometimes happens.
107 of IA.
IA, in IA, my lord,
Which IA?
918, my lord, for your lord. This, my lord, my lord, my set of. Same judge, my lord, 7 years, my lord, directed to stay in the home, my lord, and set off benefit was
Set of
benefit.
set up area of place of safety.
Yes, sir.
In that case also.
Yes, sir. It was given, my lord. But perhaps, my lord, due to some, sometimes or large judgment. So, my lord, Lordship, kindly have a look, page, my lord, section 19. Section 19 of the Act, my lord.
Judge Act.
Yes, my lord. It is clearly provided that should be tried, my lord, under as per the criminal procedure code, my lord.
Yes.
Section 19, subsection 1, my lord.
So 428 is that way applicable to cases under the JJ Act also.
Right.
Only question is whether
Appellate provision also, my
in
lord.
under JJ Act, obviously there will be no jail.
Yes, sir.
428 also does not mention jail. It only says period of detention.
Another judgment,
But
Lordship.
only my page, my lord, section, my lord, 101 of the appellate provision, subsection 5, my lord. It is also provided where, my lord, appeal, my lord, as per CRP. So trial is always as per the CRP. Actually, my lord, the entire, my lord, scheme of the act is, my lord, reformative to correct a person, my.
Is that also correct, Lordship? But if prior to time, Lordship, he is giving the benefit of that, what my learned friend is, Lordship, he will,
This also does not deal with JJ Act.
Lordship, not judge.
No, my lord,
not
I have seen, my lord, in everywhere, my lord, in the net, I searched, my lord, always provided, my lord, set off is there.
regarding
Everywhere.
428,
Not a
Lordship.
single word, my lord, I have found, my lord, so far, my lord, that should not be, my lord, said.
You have any copies of those?
My lord, these are, my lord, observation of scholar, my lord, of law field, my lord, various.
No, we want to see the practice if that is the practice.
Yes, my lord, but my learned friend perhaps also search a lot, but not find in judgment, my lord.
All just
But,
at this stage, Lordship, by my submission only on that,
Rightly point.
whether 428,
That, my lord, he is, my lord, in always, my lord, rather he, my lord, as per my instruction, my lord, he is rather, now he is in convenient place because for larger time he is to spend, my lord. Now he is convenient place with all the facilities. Because he had to spend longer time. Earlier, rather, my learned friend is thinking that, my lord, earlier he was in convenient place. Now, my lord, suppose he was initially shorter period during the.
Convenient, inconvenient, we are not concerned. We are
Yes.
considered whether that can be considered as detention.
Give in confinement.
Was he free to go out?
Yes, my lord.
Lordship.
What lordship? Was he free to go out when he was in place of safety?
My lord. This is the
Then
right, my lord.
he is in detention.
Lordship, he was not in police custody, in a residence, Lordship said.
But he was not allowed to go out.
He was not allowed, Lordship.
So detention.
Lordship, because he is under trial, Lordship, on trial, Lordship.
So even now he is not in police custody
No.
or judicial custody.
No.
So in that case, his sentence will never be over.
No, I am not on that, Lordship. He has committed such a heinous crime, Lordship. The court is to examine, Lordship, the what learned court below has.
No, we cannot consider that. If 428 is to be followed, that is mandatory.
Yes.
It does not leave any discretion to the court either to set off or not to set off. It is mandatory. It
Mandatory.
has to be set off. Whatever the heinousness of the crime.
But that also, Lordship, whether he was in jail.
Can we override 428 and say that it is directory?
No, Lordship, I am on that, Lordship. If he was in jail, Lordship, 420, it is very much applicable.
He is not in jail even now.
He is in reformation law.
So he will never complete 7 years in jail.
No, Lordship, he is.
Because he will never be in jail.
Lordship.
Then, if that argument is to be accepted, that it is only in jail, then you are in another way saying that 428 is not applicable.
And at least, my lord, I have referred one judgment of the same.
Whereas section 9 is there,
Lordship.
19, sorry, which makes provisions of CRPC applicable to proceedings under the JJ Act.
Applicable. JJ Lordship is a registration, Lordship. But commission of offense, Lordship, is a very.
At least, my lord, I have produced one judgment, my lord, the same court, my lord.
Yes.
The same 7 years, my lord, staying, my lord. Page 107 of my lord, by IMI.
It was passed by the.
Because, my lord, due to, my lord, pen mistake, my lord, So just pen mistake, long judgment, my lord, perhaps current judge, my lord, to the set of. Otherwise, my lord, same judge he has given, my. You are aware of the law, my lord. Page, my lord, IL Lordship kindly will look 107, my lord.
Yes, we have seen that.
Yes, my lord. Given, my lord, 7 years, my lord. When it was given, my lord, that set of. You are aware, my lord, but it was missed.
Lordship in paragraph, 107, paragraph 99, Lordship. In view of the above, the period of underwent by this TICL, the observation home shall be set off for the period of sentence, that is 7 years. Thus, TICL at present is aged about 18 years and 3 months. Hence, he is kept in the place of safety observation home till attaining the age of 21. And thereafter, the sentence is to be served out in the jail.
Which paragraph?
That is, my learned friend is referring paragraph IA, paragraph 99, Lordship, 107 page in IL.
.107, my lord.
IA page 107, marked as paragraph 99. What my learned friend is referring by annexing another as well.
Paragraph 98 and 90.
99, my lordship, is the vital, it is bold. Letter it is written.
First day, my lord, I also point out that this aspect was not spelled out in my judgment. It was the decision of the court said that, my lord, after completion of 21 years, the home, my lord, he may be transferred to the my jail. My lord.
And the sentence is to be served out in the jail custody.
This is my-
Last line of paragraph 99 law. He is rather he is the offender.
In my case, my lord, this two aspect is not given, my lord. This set of given here, not given, and it was directed here after 21 years should be transferred to jail, my lord. This part was also not given. And both the provision is, my lord, statute.
No, 20, after attaining 20 years, he will, do 1 years, he will be in jail. That is a separate issue.
He may be
Provided his sentence is not over by that time.
Yes, ma'am. He may be released also, my lord, as per act.
We are on the question of set off only.
Lordship.
In this case, it appears that the set off pertain to a period when he was still he is in observation home. Is it not?
Yes, my lord. This is I am paying, my lord. But in my case, same judge, my lord. I will just. It was not.
No. There is, he was not in a place of safety.
Yes.
He was in observation.
That's the same, my lord, as per act. Or what? Or is it? Sir, my lord, all
If it is same, then why two different definitions?
Yes.
Yes, only thing is, my lord, I am
While
understanding,
100
my lord,
friend is
I
making
may be allowed to
confused,
point out, my lord, when, my lord, inquiry period, he may not be, my lord, a small period, he was in, my lord, a small house, my lord. Then, my lord,
In the same paragraph 19, it is said he is to be kept in the place of safety within bracket observation home Silchar.
Yes, ma'am. Same, my lord. As per act is same. Or what is it, the act? When bail is not granted, he is then.
Can you obtain instruction if observation home and place of safety is the same thing?
Shelter home.
No, not shelter home. Shelter home is not involved here. We are on place of safety. It is called.
It is in the act, it is given, lordship, kindly, just, my lord, section, my lord, 12 subsection 2, my lord. 2, 3. Section 12, subsection 3, my lord. When he was not released on bail, when such person is not released on bail under subsection 1 by the board, it shall make an order sending him to an observation home or a place of safety.
Lordship.
So it is for accused.
Yes, ma'am.
Place of safety is defined, Lordship, in 2000 Act, Lordship, Juvenile Justice Act. That book, Lordship, Q.
No, we have gone through that definition, section 47 or something.
Lordship, and also in 2000 Act,
49.
Lordship, place of safety means any place or institute not being a police lockup or jail, the person in charge of which is willing temporarily.
Convenience child, my lord, there was some care and care, nothing else. Otherwise, all are jail. Only as he is a
Page
child, my lord.
64
some
of this
special, my
book,
lord,
Lordship.
care is
Page
contemplated.
64. Let me. Let me give it. Both of us. Place of safety means Q. Section.
We don't have to go there, just come to section 49 of the main act.
Lordship.
2015.
Act.
State government shall set up at least one place of safety in a state registered under section 41 so as to place a person above the age of so and so or a child in conflict with law
Wow.
between the age of 16 to 18 years and is accused of or convicted for committing a heinous offense. So if a CCL convicted of committing a heinous offense is to be placed in a place of safety, then can you say it is not a place for detention? A person convicted of committing a heinous offense, will he be placed in a place of liberty and freedom? After conviction, if he is to be placed in the place of safety, then it must be a place where people are detained. Otherwise, he can stay at home also.
Comparatively, he is wider place now, my. My learned friend is saying he is enjoying everything.
What enjoy, because my lord, it is a reformative act, my lord, to correct, my lord, a person, my. The concept. Longer period he is spending.
Observation home, I think Silchar, it is at Meherpur.
Yes,
Lordship.
And I don't think there is any separate place of safety there. I have never heard of it. I would have. Anyway, you can take instruction from Social Welfare Department,
Lordship.
whether any separate place of.
One, my lord, one. Meherpur, my lord. I have also taken it.
And in Hailakandi, there are only UTC, UDC. There are 2 homes are there, like
Temporary.
temporary.
It is just like designating this
Yes.
part is place
Yes,
of
yes,
safety,
correct.
this part is
Yes, ma'am.
like that only.
Fakir one.
And Hailakandi town.
They're all same, my lord. Only, my lord, as per my lord, his age, my lord, some, my lord, care and precaution must. Otherwise, always.
Yes, and you have not argued on the main merits of the appeal
Yes, my lord, no.
because we were detained by this question.
Yes, ma'am.
So, what is to be done now?
I have shown, my lord, at least one judgment of the same court. You have missed, my lord. Otherwise, my lord, the honorable judge is aware of the law, my lord. Otherwise, they would not have passed through judgment.
That judgment itself indicates that observation home and place of safety is the same. Within brackets, he writes
Same,
observation home.
same, my lord. And Act, my lord, 12, subsection 4, or observation whom or when section, my lord, 19, subsection 1, Roman 1, my lord. CRP is as per CRP style. Appellate section, my lord, 19, subsection 1, proviso, my lord, Roman 1.
Some economic question in the net, Lordship, safe home and correction home.
And my lord,
like a
in the
personal-
appellate provision also, my lord, section 101, subsection 5, appeal should be tried and heard, my lord, as per the CRP.
Agreement.
I think we should actually, since it is a regular appeal,
Lordship.
unless both sides were agreeable, we have to hear on merits also.
Merit, my lord, nothing left, because, my lord, 7 years.
So we'll say you have nothing to argue on merit.
Yes, my lord, only, my lord,
All-
set of part, my lord.
all CAB.
Keep your blame.
Much obliged, Lordship.
All right.